The Medical Marijuana Act. Senate Bill 2095. As always, it's going to be linked in the description. And as I go along, I'm going to talk about which line numbers are which. This is an extremely long bill. For starters, it's 445 pages long, and just the title itself of this bill is 189 lines long. I think it's over 11,000 total lines, 445 pages. We're not going to go over all of it. We're going to go over the parts that's probably going to matter to the general public. The length is done on purpose, the 445 pages. Anytime that something like this big change happens, they have to go through and change each individual law that will anything that has any reference in the past dealing with marijuana or the sale, the consumption, the use, doctors, taxes, criminal code, traffic code, all those laws have to change. That's the reason why this is so long. That's why I said we're only going to go over the parts that really matter to the general public. When you ask your questions in the comments or anything of that matter, I'll go through and do a different videos answering your questions and trying to comment on all of them. I've got a feeling this is going to be one of the bigger videos. Probably have a lot of comment. I may not get up to them all. It may be other videos, so don't forget to subscribe. I said the first 190 lines are going to be the title, so we're going to start with lines 193 through 474, or just the definitions. The definitions are going to be important because each definition may have a different meaning in this law as they do into other things. So if you hear me say something as in referenced in here, go back and look at the definitions and it'll probably break it down a little bit more. How to get the medical marijuana card is going to be lines 475 through 492, but I kind of broke it down to make it easier. You got to be diagnosed by a practitioner with whom the person has a bona fide practitioner-patient relationship within his or her scope of practice, having a deliberating medical condition for which the practitioner believes in his or her professional opinion the person would likely receive medical benefit for the medical use of cannabis. This is where it kind of leaves it open because it does say their professional opinion. As we get through, I will list what they have already deemed as a medical condition that needs it, but it kind of leaves it open for your doctor to kind of say, okay, yeah, this person may need it, it may benefit this one, or it may not benefit this person. So your doctors are all going to be a key player in this. 4. Has received a written certification of the diagnosis from the practitioner. 5. Has been issued a registry identification card from the Mississippi Department of Health under Section 12 of this Act. Just keep in mind of this section as we go through the bill. I'll go over it when we go through. This is going to be your first part of it, how to actually get it. So go to your doctor. Actually has to be a doctor that you're going to use and probably have used in the past. You're going to have a medical condition that is deemed worthy by your doctor or a benefit from the marijuana or the cannabis use that will help your condition. Have it written certification and have your registered identification card to the Mississippi Department of Health. They're going to be the ones controlling this, so it's going to go under health. There's going to be a lot of HIPAA laws involved in this too, which is going to kind of play against you and for you when it comes to the criminal side, because there is still going to be criminal laws attached to cannabis or marijuana, whatever you want to call it for this. We'll use both. What medical conditions does this include? So it's going to actually fall underneath your definitions on line 299. So you can click the link, go over it, gives you a little bit more detail. Cancer, Parkinson's disease, Huntington disease, muscular dystrophy, glaucoma, spastic quadriplegic, positive status for human indeficient virus, which is HIV, the acquired immune deficiency syndrome, AIDS, hepatitis, ALS, Crohn's, ulcerative colitis, sickle cell anemia, Alzheimer's disease, augmented or dementia, post-traumatic stress disorder or PTSD, autism, pain refractory to appropriate opioid management, diabetic neuropathy, spinal cord disease or injury, or the treatment of these conditions, a chronic, terminal, or deliberating disease or medical condition, or its treatment that produces one or more of the following: wasting syndrome, chronic pain, or intractable nausea, seizures, or severe and present muscle spasms, including but not limited to those characteristics of multiple sclerosis, or any other serious medical condition, or its treatment aided by the Mississippi Department of Health as provided in Section 9 of this Act. Okay, that's just something they've already pre-listed for us. That's kind of self-explanatory. As you can see, there's a pattern there. Lifelong diseases, lifelong ailments, chronic pain, something that's not going to be treated and gone in just a few weeks, few months. It's going to be with you forever. You can pretty much count that in, but I'm not a doctor. See your doctor. They'll explain it more. What is required to be on the certification. This is going to be lines 494 to 505. Has to show it was made in the course of a bona fide practitioner-patient relationship. That keeps coming up for a reason. There's going to be their way to try to limit some of the fraud that's going to go on, because there's going to be some in the beginning, and as the course goes on, people will find ways around things, which this is where those definitions come into play. Go back to 199. Remain current for 12 months or a shorter time period. When your doctor writes your certification, the most the state will allow it to be good for is 12 months. Your doctor can write it for a month, 6 months, 12 months, but it can only be 12 months long. Then you're going to have to go back to your doctor and get another certification letter. Be issued only after a in-person assessment. You have to be in person. You can't do telehealth, telemedical. This is what I've read in the thing so far. They could be meaning something different. They may let telemedicine, but as of right now, in person specifically says in person and a bona fide practitioner-patient relationship. To me, that means it's going to have to be your everyday doctor, the one you've seen for a while. 4. Only be issued to a minor if the parent or guardian is present and provides signed consent. They will allow this to be given to kids. Kind of strange going from what we went to on the laws to this, but minors can get it also. Be limited to allowable amount of cannabis in a 30-day period. We'll get to that next. So your certification is, just to break it back down, go to your doctor in person. 12 months or shorter, has to be a written certification. We'll come into later how that goes into effect. Okay, what is the allowable amount? That's going to go to line 362. There's going to be 3 options here. First option is 3.5 grams of medical cannabis flower. 2, 1 gram of medical cannabis concentrate. Or 3, 100 milligrams of THC in an infused product, which that's going to be your edibles, gummies, whatever. All right, now you got your certification. How do you file for your card? When you get your certifications, you got to go to the Mississippi Department of Health. You can do this online. There'll be a form you have to fill out. You're going to have to pay a fee for your card. It's going to be a background check you're going to have to pay for. This is going to have to be done for every time you go to get your card, or every time you have to renew it, which could be once a year, however your doctor does it. Then we'll get to further on about what's actually required. Now you got your card, you can go to your local dispensary. Don't forget to shop local. Support your favorite legal dealer now. I mean, that's about the only way you can really say it. And you will need to make and have a follow-up appointment no less than 6 months from the time you receive your written certification. How strict that's going to be, not sure, because of the limitations of it. If your doctor writes it for 3 months, I'm assuming you may not have to do your 6-month follow-up, but it's in there as a form of way to keep your card. Everything will be tracked as far as your card. So when you go to your dispensary or everything, you need to have your card, your ID. And if it's like most things, your ID has to be current and valid also, or you won't be able to use it. They're going to track everything you do with this, and which brings us to our tracking system. There's going to be a statewide tracking system. It's going to be lines 723 to 776. Like I said, some of this is going to be dealing with you as the public. Some of it will be dealing with the dispensaries, the processing plants, the transportation. But as the limitations to the general public, the tracking system will track every aspect from the seed to the cell, and that's what they actually call it. I think it's like metric or whatever acronym or whatever they're going to use for it. I'm pretty sure it's called metric. But once the cultivators, the growers, they get their seed, it goes into a system. They have to log every seed, every plant, everything they do, how much they harvest, how much they destroy, and then what gets transported. Every bit of that's tracked all the way from they get it to the transportation to the processing facility. From the processing facility, it gets back transported to dispensaries. Every bit of that's tracked. The weight of it, all the way from start to finish, is tracked. Then they will also be a tracking system, pretty much like a pharmacy does. Once you go into a place and you only get half your prescription, or whatever they're going to call it, whatever you get your dosage of it, it goes into a statewide tracking system. You can't go to the next town and think you're going to get your full amount, because it's going to be tracked, and everything you do, everything you request, to what I can tell, is going to be tracked. So once you start hitting different dispensaries, there's going to be a note of it. The state's going to know, the tracking system's going to know that you're hopping from dispensary to dispensary. So keep that in mind when you start doing all this. And also, some of this information is shared, not necessarily your personal information, but this tracking system does share some things with what I saw was to financial services, but who quite knows at this point. There is some limitations to this act that starts at line 777, goes to 851. This act does not mean your employer or organization has to change their policies or views on what they are willing to allow as acceptable on a drug test. Also means they can refuse to hire you, and is not a legal argument for a lawsuit. This is specifically put in there. So if you're going for a job and they deny you because you have a prescription or you're granted medical cannabis, can't sue. It's written in the law that way on purpose, and I'm assuming they're expecting you to know this if you get into the medical cannabis program, that this is going to have to be something you're aware of. And that also goes into state that you may not be covered on your workman's comp. So if you are working somewhere and you get hurt, workman's comp may not cover you. And your employee is not required to offer you legal defense in a workman's comp issue. So you're starting to see these issues that are going to pop up. These are going to happen. People are going to do it. Cannabis stays in your system for a while on a drug test. So something to be aware of. If you get hurt and they drug test you, it could be 2 days later and it's still in your system on a drug test. You're going to have a hard time fighting a workman's comp issue, and your employer is not required to offer you legal defense in that situation. Your health insurance is not required to cover any part of this treatment. That's also in there. So don't think you're going to be able to just go to your doctor for this and your insurance is just going to cover it. Which to me, it's kind of weird if your insurance don't. They'll cover a pill that may cause you to be addicted for the rest of your life versus this, but I don't write the laws. I don't write your insurance policy. It does not cover a rule or a probationary or pretrial diversion program or other court order substance abuse rehabilitation programs or drug court. If you're in any type of legal situation and they tell you no drugs, no weed, no cannabis, whatever, this law does not protect you against that. You can still be found in violation of whatever court issue was given. It cannot be used in any public place or when you're in a control of a vehicle, aircraft, train, motor vehicle, motorboat. So all those same rules still apply. Same way as with medication, just because it's prescribed to you don't mean you can do it and drive a vehicle. And you cannot possess any amount over what the doctor allows you to have. Keep that in mind. So if you get prescribed something and you have leftover and you put it in with your new bit you get stopped or anything of that nature, and you have more in your possession than you're allowed to have on your medical marijuana card, you're going to be in trouble. Discrimination. This can be lines 852 to 876. You cannot be denied custody or visitation rights solely for the person's status as a card holder. The word solely in that leads me to believe it could be one factor or many, but can't be only one reason. The wording there just kind of says solely for that reason of being a card holder. If you are other issues or, I don't know, I just don't like the wording of solely there. To me, it bothers me, so me reading laws and going over them, and it bothers me, there's probably going to be an issue there. So I'm looking forward to see how that turns out, whether it's good or bad. So if you're going through a custody issue, this may come up. You cannot be denied by a school or a landlord for being a card holder. To me, this goes into one of those situations. I'll be shocked if they're allowed to actually ask you. That'd be kind of asking your future tenant what kind of medication they're on before you allow them to stay. And to me, that seems like a weird scenario of a HIPAA violation. It may not be. I could be misreading that wrong, because in another later part, you'll find out why I say that, and I'll bring it back up. You cannot be denied your Second Amendment rights for being a card holder. That was my biggest issue, because I know some places, if you're on drugs, you can't have a gun. And this is still considered a drug. And it's one in the past that if you had a firearm and this drug, it was a whole separate crime. But now being a card holder, you can't be denied your Second Amendment rights. What if your medical condition was not listed in the above medical conditions to be a card holder? Lines 877 to 888 covers that. It's possible you can send a petition in to the Mississippi Department of Health to add a serious medical conditions to be approved to the list, and they shall provide you with a response within 60 days. If they deny you and you're not happy with that response, there is another way. You can get a final decision with a judiciary review. And if you're denied, they will send you a letter explaining why you're denied, but they will also let you know that you're denied. You'll have a response within 60 days. Then you can do your judiciary review. Goes through a board. They look it over and discuss it again. Then what I can tell, that's your final review. You get the regular review, then you get your judiciary review. Once those two is over, I don't think there's any other way to petition it. Section 10 will be line 889 to 904. Nothing in here says that government programs or any insurance is required to pay or reimburse you for any part of the program. We're going back to that. It's stated here in different places. They're doing that to state that if you want this program, it may be 100% out of your own pocket, and that's just going to have to be something you're going to have to pay it if you want it. Your employer can punish you for the use of medical cannabis. You are not protected under any of the employment laws so far that I can tell. So this is going to be something you're going to need to discuss with your job. They may keep you, they may let you go. That is well within their rights. Earlier, we went over it's not allowed in public places, but under this section, it says people and establishments can allow you to use it on the property. That one's going to be a strange issue because of that previous not use in public. But most of your public establishments are private property. If they allow you to do it, then they allow you to do it. This is going back to your landlord. Landlords may allow it, but are not required to allow it. The earlier statement says they can't deny you the rental because of the card holder. They can allow you to be there and still say, I don't want you smoking cannabis in my rental. So they're not denying you the place to live. They're just denying you the use of the marijuana in the building. That's going to be the two there. Lines 928 to 1032. When can you apply for it and what do you need? You can apply now. You can go ahead and try to go through your certification. I don't think that's a good idea. I would wait because right now there's no product to sell. Your cultivators are just now getting their license and their seeds to be able to grow the marijuana, and it has not been grown. It has not been transported or processed. So I think you'll be wasting your money if you go ahead and do it now, but you can go ahead and start talking with your doctors because your doctors are going to have to go through a yearly training to be able to do this. If you do it now or whenever you do it, you must turn in your certification. That's where you get it from your doctor. Pay the fees, have your name, address, social security number, date of birth, and name, address, telephone number of the practitioner issuing the certification. And the same information if a caregiver is giving it to be involved. If your caregiver is going to be involved in giving this product to you, they also have to file for a ID card so they can transport it for you or be in possession of your medical marijuana or cannabis. The Mississippi Department of Health will verify the information and they have 30 days to deny or approve your card. If you are denied, they will give you a written reason as to why you were denied. Let's touch on that caregiver thing there because we haven't touched on it yet and kind of skip over it because like I said, the general public is not going to be part of that. Caregivers can apply for their own card. Their card will be slightly different than the user's card. The caregivers will have their own personal information on there plus the information of the people that they're responsible for or they're going to be toting the marijuana for. They'll have to go through a class also, so that's going to be slightly different than what the general public will have. Like I said, they have 30 days, and 30 days you're still not going to be able to get it from a dispensary. So even if you have this card, you go to your doctor, get the card, it's still technically illegal because none of your dispensaries are open. There's no product to sell. So if you have this card and you have marijuana on you, it's still illegal because you didn't get it from a dispensary. All right. Your cards, lines 1033 to 1078. Your card will have your name on it. It'll have if you're a patient or a caregiver. Like I said, if you're a caregiver, you'll have a unique number for you and you'll have a unique number for it'll have the other person's number and information. It will have the date the card was issued, the expiration date, a random 10-digit ID number that will contain at least 4 numbers and 4 letters. It will have the photo of the card holder, a number or site to verify the card, a notice of harm for cannabis, kind of like they do the Surgeon General warning for cigarettes. You'll have a notice of harm for the cannabis, the amount that you are allowed to have. This is going to be one of those situations to where even though this goes to the Department of Health, these cards are going to be for law enforcement, it's going to be for your dispensary and for your doctors. You have to have this card on you if you're going to have it around, if you're going to have marijuana on you. This card right here is how we verify that you are a medical marijuana card holder. It'll let us know if you're still valid. It will let us know how much you're allowed to have. If you do not have this, you go back to the old way, it's automatically illegal. Can't have it. Don't matter if it's in a packaging you got from the dispensary. Does not matter. Without this card, it's illegal. As of right now, there's no way to check other than having this card. That's why you'll have your unique card number. It's not the same as your ID. It's not or your driver's license. It's not the same as your social. It's going to be a very unique number just for you. There'll be a link. And there was talk of putting a QR code on there, so you just hit it with a phone, computer, you type it in. It'll tell you whether they're valid or not and how much they can have. I'm not sure if it'll tell us when you got it, when your next pickup is. All of right now we know that there'll be a link on there. You'll have your ID card number. We'll be able to tell if you're valid or not, and we'll be able to tell how much you have or are allowed to have. All right. So far, the only prices that I've been able to find for these cards is $25 for the card itself and $37 for a background check. That is liable to change. That may be what it is for a while, maybe for the first year. That is the only numbers that I've been able to find that actually state a price for the card and the process of getting the card. Lines 1079 to 18 are just the annual reports required by the state. Every bit of this is going to be recorded in that system. There's going to be annualized reports. There's going to be a lot of paperwork that it's going to be required by the dispensaries and everything that matters. It's not going to affect the day-to-day user. Lines 1119 and 1144 are just going to be the verification system and the data that's being gathered. So if you're curious about what data is going to be gathered, you can look at those lines. It'll tell you. 1145 to 1191 just states responsibility for the information given and the notified in the Mississippi Department of Health for any changes. If you have any changes with your address, your doctor's visits, it is your responsibility to notify the Department of Health. Same way with your ID. If anything changes on your ID and you do not notify it and have it changed that point forward, it's no good. It kind of cancels itself out if the information on there don't match the information that's actually correct. And it's your responsibility to change it. All right, 1192 to 1499 just covers dispensary reports and the rules of the cultivators. Just because you're a card holder does not mean you can grow it. So let's go ahead and get that out of the way. You are not allowed to grow it. Only cultivators are allowed to do that. Lines 1500 to 1550 states that municipalities and counties can create ordinances against certain parts of this act, but cannot deny this act. There was a toss-up when this first came out in my area about, they're going to vote against putting dispensaries in, but according to this, they can't stop that. They're going to have to allow it. Lines 1558, pretty much to the end, covers the law changes, the business aspect of it, goes over all the medical laws. All of the old marijuana laws are still in effect. This is only covering medical use that is done in the medical fashion. And if you break any part of that, you're going to go back into breaking the law. It's going to go be the same as it was in the past. Do I think it's probably going to be less of an issue now? Probably. I think that this is going to be a situation where it's going to be so widespread that they might as well just legalize the whole thing and just increase the taxes, which, as I can tell so far, I was hoping for a huge increase of taxes on it. That way we can do away with state income taxes, but that don't look like that's going to be the case. They're going to keep the same sales tax. This will not be able to be in tax exempt in any form. Like when they do tax-free weekends, it's not going to be a part of that. Looks like it's going to be regular sales tax. So the people who are going to be using this program, there you go. It's not going to be heavily taxed. I would prefer, this is my opinion, I would prefer they up the taxes on it so I could pay less state income taxes. Just my personal opinion. Maybe if they do recreational, increase the tax on it, do away with state income taxes, and leave medical marijuana at normal taxes. I'm okay with that too. This is going to be a whole new adventure for everybody involved, even law enforcement. There's no case laws really set forth for this. As you know, the smell of marijuana gives us consent to search a vehicle. This is where keeping your card on you is going to be key. And if you're a card holder, you get stopped and they smell marijuana, you have to prove the amount of marijuana that's in the vehicle. That is going to be a responsibility on the people in the vehicle. I guess we can answer questions on this as it goes on. So I'll be here. My email address will be down here. You're going to end up with a lot of interactions you're going to see from different law enforcement officers, because some are just not going to deal with it. They're not really kind of caring. You're going to have some that's still going to push the old ways and the old issues. It's going to be interesting to see all the way around. This is where the knowledge of the laws are going to come into play. It's always easier to comply on the street. Don't have court on the side of the road. If you feel like you're solely in the right, take that up in court. Let that be the issue for the judge, because you may be right, you may be wrong. Same way with that officer, because this is going to be a new adventure for everybody. And that's the whole reason why I put the links in there. If you have an issue or you think of something that may come up beforehand, please let me know. I would like to hear your concerns also. People in the comments may want to know your concerns. They may have the same concern. Let's try to work this together and see if we can't come up with the answers. My opinion would be you can't really use it in public places. Once you go, you leave your doctor or you get your new prescription, or however you want to call it. You go to your dispensary, you pick it up, you take it home. Leave it at home. You can't do it and drive, so you're still going to do your DUIs. It don't matter if you can get it legally or not. You're still going to be governed by your DUI laws, so you can't just get it and go. It is going to change your paraphernalia laws, because you're allowed to have paraphernalia now. It's not going to be called paraphernalia. It's actually the objects used to consume your choice. You had your three choices of how you wanted it: the edibles, the flowers, or the concentration. You'll be able to do that now, so that's going to be another booming industry that's going to stem off this. Going to be your pipes and any other way that you're going to consume it. Hopefully, for the most part, as this kicks off, I answered your questions. If I didn't, comment them below. Email them to me. If you don't want to comment them, you want it to be email, you make a fake email. I don't care. Just email your questions. Let me know if you want me to do a video or just try to answer it. I have answered a few people's emails that have sent them. I can't answer your question if I don't know it. And as always, have a great day.